Okay, great. We're live.
All right, good morning. It is February 27th. We're in Judiciary. We're picking up S45. And we're starting off with Scott Sanderson from the Conservation Law Foundation. So, yeah, floor source.
Good morning, Chair Hashim, Vice Chair Norris, members of the committee. My name is Scott Sanderson. I'm the Director of Conservation Law Foundation's Farm and Food Program. I'm a staff attorney. I also manage the Legal Food Hub, a free service that connects farmers to pro bono legal assistance. Thank you for the opportunity to testify on S45. CLF opposes S45 because it doesn't solve the problem. Nuisance and trespass lawsuits against farms are rare. They don't threaten Vermont's farm economy. Moreover, S45 upsets the careful balancing already established by Vermont's existing right to farm law. It curtails property rights by extending right to farm to include trespass, and it limits Vermonters' recourse to the courts when they have no other option to protect their property, health, and welfare. So I'd like to start by discussing the purpose of right to farm laws a little bit. Right to farm laws offer legislators the opportunity to calibrate the law of nuisance to the needs of communities where agricultural and non-agricultural land uses mix. So as you know, the law of nuisance protects property rights. Specifically, it protects your right to use and enjoy your property free from substantial and unreasonable interference caused by neighbors. That's why the law of nuisance is sometimes known as the good neighbor rule. Now, nuisance isn't about taste, it's about harm. And that's why the Vermont Supreme Court has explained that the unsightliness of a thing without more does not render it a nuisance under the law. Instead, a nuisance has to concretely interfere with your use of your property as judged from the perspective of a normal person in the community. And of course, in an agricultural community, the normal person understands that living in an agricultural community means accommodating farms. So a neighbor doesn't have a nuisance claim if they simply don't like how cows look or smell. But a neighbor might have a nuisance claim if a farm begins to do something that causes a toxic chemical to waft into the neighbor's house every day. Now, right to farm laws offer farms extra protection from nuisance lawsuits. They recognize that conflicts sometimes develop when non-agricultural land uses occur in traditionally agricultural areas. And well-crafted right to farm laws respond to that potential conflict by protecting farms from unfair nuisance lawsuits while preserving their neighbors' use of the courts when that use is justified. So that makes right to farm laws a bit of a balancing act. They balance the farm's right to farm free from harassment with a neighbor's right to use and enjoy their property in good health and safety. Now, Vermont already has what I consider a well-crafted right to farm law that discourages unfair lawsuits against farms. It gives farms facing a nuisance lawsuit heightened protection if the farm can show that the activity that is alleged to cause a nuisance is consistent with the law, is consistent with good agricultural practices, existed before surrounding non-agricultural activities, and did not change significantly since the surrounding non-agricultural activities began. And I think that makes sense. The idea is to protect farms that comply with the law, whose activities are agriculturally sound, and whose neighbors were on notice when those neighbors arrived in the community. Now, the extra protection that farms earn isn't absolute, and it's a good thing. Instead, it forces the neighbor to prove that the harm is uniquely severe. So instead of just needing to make a normal nuisance claim, they have to make a heightened showing. So the neighbor has to prove that the agricultural has adverse effect on health, safety, or welfare, or has a non-significant interference with the use and enjoyment of a neighbor's property. That's a much higher bar for the neighbor to overcome. So Vermont's right to farm law, it basically sets up a back and forth, a very balanced back and forth. It starts with nuisance, then it gives the farmer the opportunity to gain extra protection. And then if the farmer gains that extra protection, it preserves the neighbor's ability to resolve particularly severe harms. So I think the question is, does that work? Does Vermont's right to farm law actually protect farms from unfair lawsuits? And as far as I can tell, it does. To my knowledge, only one nuisance lawsuit has been filed against a farm in the last many years. That lawsuit, to my understanding, proved justified as a justified step towards abating significant harms. Now, I'm not going to get into that lawsuit because I see from the witness list that you'll be hearing from folks who are much closer to that case than I am. I'll just say that, in my opinion, what we've seen indicates that there isn't a problem for S45 to solve. But all the same, I'm going to shift to S45 itself, which is the alternative to Vermont's current right to farm law, the proposed alternative. And I think that it proposes several changes that limit property rights, that undermine the careful balancing that characterizes Vermont's existing right to farm law. So I think the first thing to focus on is that S45 expands right to farm protections to include trespass. This would be a pretty significant, actually quite a dramatic policy change. Trespass, unlike nuisance, protects your right to exclusive possession of your property. In other words, it prevents someone from entering your property, from using your property, or from causing something, for example, sewage, from entering your property without your permission. In the way that most people think about property, is trespass, the law of trespass, what makes your property. And what that means is that S45 curtails fundamental property rights, and it does so in a way that can prevent Vermonters from invoking the law of trespass to prevent themselves, to protect themselves from farm activities that are causing serious harm or concretely damaging their property. And I think that's a problem. I'll also flag that a few years back, there was a right to farm law in Iowa that only addressed nuisance, but that went very far. And the Iowa Supreme Court got involved because they were concerned about that right to farm law working for constitutional takings. And so I think something to watch out for with a law like this that goes as far as to offer trespass protections, I would think about the takings implications for that too. Now, the second thing that I focus on with S45 is that it eliminates that back and forth that I described under Vermont's current right to farm law. Instead of giving farms the opportunity to gain extra protections, S45 automatically blocks nuisance and trespass lawsuit claims unless the neighbor or the plaintiff can show that the farm has violated a subset of Vermont's agricultural water quality laws. So that's only the Title VI water quality laws, has violated Vermont's pesticide regulations, or is engaged in an activity that is uncommon on similar farms. So if a neighbor can't show one of those things, it doesn't really matter if they establish evidence of severe harm, nor does it matter if they demonstrate an adverse effect on health, safety, or welfare. Their ability to protect their property, their health, and their welfare through the law of nuisance and trespass is simply cut off. Now, it's true that S45 attempts to repair that imbalance by clarifying that its protections don't apply whenever a nuisance or a trespass violation results from the negligent operation of an agricultural activity. But that doesn't really help here, right? Negligence is a legal claim. It's one that neighbors can assert independent of nuisance or trespass. Moreover, it's important to note that negligence isn't really a property claim. It doesn't turn on whether or not a farm violated the neighbor's property rights like nuisance and trespass do. Instead, it focuses on whether a farm caused harm by breaching a duty of care owed to a neighbor. So basically, the net effect of S45's attempted balancing is really to trade away neighbors' property rights for a different claim that neighbors could already make. It trades away something they had for something that they already did have. The last thing I'm going to mention is that S45 protects farm activities that are not regulated by a subset of Vermont water quality laws, again, for Title VI water quality laws, or by Vermont's pesticide laws, if those activities are conducted in a manner that is consistent with proper and accepted customs followed by similar operators of agricultural activities in the state. And so, in other words, to determine whether an otherwise unregulated agricultural activity is causing a nuisance or trespass, S45 asks whether the activity is common on similar farms. If the activity is, then it's deemed neither the cause of nuisance nor trespass. And I think this standard ignores that a common agricultural practice implemented in a common way might cause substantial harm if it's implemented in the wrong circumstances. And I think, as you go through the case and as you listen to other witness testimonies, I think you'll start to see examples of how that might happen. Okay, so just to wrap things up, I don't think there's a significant problem for S45 to solve. Vermont already has a well-balanced right to farm law. It prevents unfair lawsuits against farms. And by contrast, I think that S45 undermines property rights and limits Vermonters' ability to protect their health, safety, and welfare, particularly when the government fails to act. And so for those reasons, CLF proposes S45. I'd be happy to answer any questions you might have.
Any questions? I did want to revisit one point regarding trespass and generally accepted practices, and the practices conducted in a manner consistent with proper and accepted customs followed by similar operators. And I'm just trying to think of real life scenarios in which So let's say there's a dairy farm next to another piece of property, and the farmer of that dairy farm randomly decides that, you know what, I'm just going to start putting my cows on this other person's property and they're going to graze over there. That, in my opinion, would be, outside of the scope of generally accepted practices, as far as I'm aware. But in the event that somebody's cow gets out, despite that farmer, taking the usual steps that most farmers would take to keep their cattle, in a confined area, I think that can happen from time to time. So, can you explain to me why? I don't quite know where my question is in all of this, but can you dive a bit deeper into why you feel that property rights would be curtailed, and why a hypothetical plaintiff, will have the ability to seek a remedy if somebody's cow gets out, or if somebody decides to just put all their cows on their property?
Sure. So I think the big problem with the standard is that it is based on the idea that industry practice establishes its own standard of conduct. And so if it is common for farms to do something in particular, that would effectively insulate farms from those sorts of matters. So for example, if there's a drainage practice that is very common on farms and it happens to be implemented on a particular farm in a way that results in damage on a neighboring property, that practice might fall under this standard as being protected as a proper and accepted custom, followed by similar operators' rights. Similar operators, you need to look for the farms that are similar to that farm, that do similar things to that farm. And despite the fact that that practice implemented in those circumstances, it's a common practice, right, done for a common reason, despite the fact that that practice would meet this standard, it may nonetheless cause damage, for example, by draining onto a neighbor's property or causing damage on a neighbor's property. I don't think it's particularly common for, a farm, for example, to move all of its cows onto a neighbor's property, but I do think it is common for farms to want to improve the drainage on their property to improve yields or to make it easier to get onto their fields earlier in the season, right? So I think that those are the sorts of examples that you would want to be concerned about.
So I mean, with the drainage example, with the drainage example, and potentially causing damage to somebody else's property, would that not fall under the negligent operation provision that is at the bottom of page 5?
It may. I'm not sure. I think that's part of the problem. Is it's very unclear whether or not negligence would cover that. The traditional and more straightforward way of dealing with these sorts of harms is to look at trespass and nuisance, because the fundamental right that is really being breached is that property right? That's something that is well recognized, well developed in law. And so if the interest is to protect that right, to protect that interest, the straightforward way to do that is through property rights claims like nuisance and trespass, rather than to try to, reshape a negligence claim to fit the circumstances.
Thank you. Senator Burns.
Wondering what your position is on the required mediation.
Yeah, I think the mediation requirement is complicated. I understand the motivation to require mediation in advance. However, I do think that there are circumstances where you might, like, take this drainage example, right? If you have a drainage problem happening immediately, where you may have damage taking place in the moment, and mediation may not there be the way that you can abate that harm as quickly as you might like to. So there may be things where mediation is an appropriate response. I actually think that if I remember right, and you can probably ask this of later witnesses, that even in the case that came up, mediation was offered. But I do think that folks should have the ability to go directly to court if they're facing a harm and it is an ongoing harm that they want to abate immediately. They shouldn't have to endure that to make their way through a mediation process.
So just to follow up, then under this proposed regulatory scheme, you wouldn't be able to ask for a stay on the practice while it's being mediated?
I'm not sure about that.
Okay.
Any other questions? Yeah. Thank you.
Absolutely. Thank you very much.
Thank you. Morning.
Morning.
So thanks for the opportunity to testify to go for the record. John Groban, I'm the policy water program director for the Vermont Natural Resources Council. And I'm just gonna, I think, further explain and amplify some of the points that Scott made. VNRC and CLF work pretty closely together on these issues, and particularly on an issue related to water quality that I think relevant to this bill that I'll talk about. But just before I go, because haven't been in this committee in a while, and I don't think we've ever met, just some of my background. So I am an attorney. I'm the policy and water program director of VNRC, but I'm also one of two attorneys, and I work with our other attorney on a variety of cases. I served for 5 years early in my career as the Act 250 attorney for the Agency of Natural Resources and the appeals attorney. And I was general counsel for A&R for about 4 years. So I have seen these issues from in-state government and from without state government. So just to try to kind of give you a little background kind of perspective as I talk about this bill. So overall, VNRC agrees with CLF that the bill seems to be a solution in search of a problem, that we do have a right to farm law, that our understanding is it works pretty well to make sure that people can't move to where the farms are and claim that ordinary practices are nuisances, and just because they're not practices that people are familiar with before they move there. And, VNRC's concern with the bill really goes to what Scott was talking about. I think it creates a lot of confusion in terms of saying that if you wanted to bring, I'm focusing mostly on water quality because that's what I deal with. I don't really deal with other farm nuisance issues, but we've seen a lot with water quality. And I missed the beginning of Scott's testimony, so I don't know if he saw this, said this, but so, VNRC, CLF, and Lake Champlain Committee filed a petition with the Environmental Protection Agency that was based on hundreds of records that we obtained about water quality regulation on farms in Vermont. The record request was to the Agency of Natural Resources and to the Agency of Agriculture, Farms and Market. And they were a result of complaints that we had gotten about discharges from farms that were harming water quality, the environment, and neighboring properties, and that were violations of allegedly of state and federal law, the Federal Clean Water Act, and that they were not being enforced. And so we looked at these records, we submitted a petition to EPA saying that what we found in the petition is that there was disagreement between the Agency of Natural Resources and the Agency of Agriculture in terms of whether there was a violation of state and federal law. And lots of infighting between the two agencies, and that resulted in the discharges not being addressed. And we went to EPA and said, there's some violations of the Clean Water Act in here, and we need you to intervene to take action. There are mechanisms in the Clean Water Act to allow for these sort of petitions and action to be requested. EPA intervened in response to our petition, did their own review, and issued a preliminary decision that agreed that there were violations of the federal law, because that's their jurisdiction, and that Vermont needs to change the way it addresses water quality from farms under our Vermont laws. And that petition is still pending. The decision was preliminary, and we're still working through the EPA process. There've been a couple of bills that have been introduced to deal with this issue. But as it relates to this bill, what's relevant is that it's really concerning that there's so much weight putting on practices, including water quality practices, that creates this sort of threshold hurdle to liability. What we have seen through the records and what EPA validated is that the system we have for the state to determine whether it's compliance with the laws are is not working, and there's disagreement between two agencies about whether there is in fact compliance with the law. And then we're gonna, in this bill, strengthen uh, the shield basically that compliance with the law would create. And my understanding of the way the bill is structured is that it would put the burden on a plaintiff to prove a violation of state practices, including water quality practices. And
John, can I interrupt you? I'm
Sure.
sorry
Yeah,
to cut you off. It's not. So it's not often we talk about water quality, if ever, in this committee. So can you just tell me which, is that in 6 VSA 215?
part of the required agricultural practices is part of, which are referenced in the bill. It is part of Title VI.
And, okay.
Yeah, so it's caught under the umbrella of the practices that are referenced in the bill. And so I've been trying to think how this would work. So you're playing it, you have to prove by preponderance of the evidence that that there's not compliance essentially with these practices in order to go forward with your legal action alleging harm. And we just don't have faith in the like. I assume that if that lawsuit was brought and a plaintiff tried to prove, first of all, it's very hard to prove a violation. You're asking, the current law is a rebuttable presumption if there's compliance with practices, but you can rebut that presumption by showing substantial harm to your property. So you focus on what's happened to your property, as we're shifting that to now saying that you have to prove there's non-compliance with practices, which we've seen two state agencies can't agree that there's non-compliance. So we think that will be confusing and a really unfair burden on a plaintiff and confusing to the court. I assume that defendant would bring in, hey, there's no violation. You know, the Agency of Agriculture, the Agency of Natural Resources hasn't said there's a violation, that will be used as evidence that, you know, there is not a violation of the practices. And again, we don't have faith in that system to say that there's integrity to that decision or non-action that we think would have an impact in court. And then to overlay to say, well, you know, notwithstanding whether or not there's proof that there's violation of these practices, you can still bring a negligence claim. As Scott just said, negligence is based on a duty of care and not acting reasonably. And the classic negligent defense is that we comply with all the state rules, we comply with all the rules, we're doing all the things that are asked of us from a regulatory standpoint. And again, without that, we don't have really faith in that system. Now, maybe if we, like I said, there are bills that have been introduced to try to alter the system, and eventually I think we'll get a debate on that. Maybe if you had a system that there was more faith in, that was clearer, you could go this way. But even still, I think it's unfair to put a burden on a plaintiff to show non-compliance rather than harm to property, which plaintiffs in a much better position to basically say what has happened to their property rather than to basically try to stand in the shoes of agencies to say whether or not there's compliance, you know, with these state laws. And a couple of other issues with the bill that I identified is one, so the current law talks about state and federal law. This bill only talks about state law. So there's not anything in the bill that says if you're not complying with federal law, which is what EPA is looking at. So EPA's jurisdiction is federal law and the Clean Water Act. That's cut out of this bill. It's a change in the status quo of the law. You're only looking at whether you're complying with state law. And then the expansion from the right to farm protections right now from nuisance to trespass. Trespass is what triggers the water quality issue in my mind, because that is classic. And we talked about nuisance and trespass a lot. The only time I've really been in this committee is when we talked about the toxic liability bills that we had a couple of years ago. And those are all about, you know, common law actions in trespass and nuisance when there's a release of a toxic chemical from a property that causes harm to the environment or health or soils. And, you know, more than even nuisance, trespass is like the vehicle, right? Trespass is the traveling of the contaminant from one property to another. And right now, under the law, trespass is not part of the right to farm nuisances, which makes sense because my understanding of the right to farm law was, as I said when I started, and I think it's fair, you don't want people moving to an agricultural area, maybe from a place where there wasn't agriculture, being concerned about odors, nuisance, right? Being concerned about other, practices on a farm that are aesthetically, not to the liking of someone, but are just normal farming activities, and that's a nuisance. But now we're expanding it to trespass, which goes right to the basically discharge and the movement of pollution off one property to another, which, whether it's erosion, whether it's contamination of soils, of wells, what have you, it's an expansion, especially with the issues that we've seen in the administration of the water quality laws concerns us because, the civil law is a backstop, right? If you can't get relief, I have people, because people go find VNRC's website and they see we're an environmental advocacy group, and people complain to us, they send us pictures of drainage ditches and water running off of farms onto their property. They ask us what we can do about it. We say, not a heck of a lot. You should call the Agency of Agriculture and the Agency of Natural Resources because we have the system we have, and they're the ones with the authority to really deal with that issue. Or they could go sue in court if their property is being harmed, and they're not getting relief from the government. I do think that civil backstop is important, given that we've seen real problems, and EPA has validated these problems with our water quality regulatory system. And I'm sure you'll hear, the Agency of Natural Resources and the Agency of Agriculture said, well, they've heard about the problems, they're fixing the problems, it's a better situation. We still we're not convinced, we haven't seen the evidence that the problems are fixed, and EPA hasn't either, and we'll see how they resolve the petition, at the end of the day. But it's concerning to make this sort of shift in liability with those issues out there about how the government is ensuring compliance with the law. That's basically what I had to say, and our thoughts and concerns about the bill. Happy to answer any questions.
Some of my initial thoughts, without straying far afield into water quality rules, since that's not our area. My initial thought is potential for removing the trespass piece of this, but keeping the nuisance piece. But I do disagree that it's unfair to shift the burden to the plaintiff. I think the plaintiff is supposed to have the burden in proving whatever case they're bringing. Same thing, in criminal court, the plaintiff, the state has the burden of proving.
I agree with that, but the burden now is to show that's a substantial damage to your property. Now you're asking the plaintiff to prove there's a violation of law, but basically as if they were a government agency when there's non-compliance. I don't know how they don't have subpoena power, they don't have inspection powers. I don't know how a plaintiff would be able to find that out. The government has a hard enough time finding that out. They have to get onto farms or whatever the alleged violation is. They have to use its power of enforcement to do that. You're asking just a citizen to basically prove a violation of the law without, how are they going to gather evidence on that? I guess you go through discovery and try, but I think it's hard enough for the government to do it. I don't argue about the burden. I'm saying what you're asking them to prove. I would say right now it's substantial harm to your property, and you could prove that because you could say, here's the activity, here's my property, I can see what's happening, and you have to convince a judge of that or a jury. But I just don't. I think trying to convince a judge or a jury that there's about non-compliance with practices of law, basically rules, that's the challenge.
Maybe Senator Norris and then Senator Cruz.
Yeah, so along those same conversation that Senator Sheen was having. So what you're proposing is, I always thought everyone was innocent to prove guilty of any offense here in the United States, but I realize we're looking at criminal versus civil,
Right.
and preponderance controversy beyond the reason to tell, but so you're saying that the plaintiff shouldn't have the burden of proof when they accuse somebody of that.
No, I'm saying they shouldn't have to prove what you're saying. I'm fine with the way the law is now. Now they have to prove that there's substantial damage to your property. My concern is you're asking them to prove non-compliance with laws and rules and practices that the government is struggling to agree on what is.
Yes, but you didn't let me finish my question.
Yeah, sure.
With all due respect. Okay, so, but in return, you're also, you've stated this 2 or 3 times already, but in return, you want the responsibility to fall on the accused to prove?
No.
They
I want a
don't.
different standard. That's what I'm saying. I'm advocating to stay with the standard that we have in the law, and you can make the plaintiff prove that. Which is they have to prove the substantial harm to their property. That's the standard. And they should have to prove that. It's not about, it's about what they have.
Okay, thank you.
Yeah.
And I thank you for that point. I think that's definitely worth consideration. Wondering about the required mediation and what your thoughts are on that.
Yeah, again, I'm a little softer on that than my colleague from Seattle. I mean, I think Scott made a good point about, I think it's a good point about if there were immediate harm about having some ability to get a stay or something to deal with that. But I think Senator Campion had a similar bill last biennium. I mean, I think that generally it's a good concept. I mean, you want people to work things out. And so I support the concept, and I'd like to think about what Scott said about maybe a tweak to how it's implemented.
A tweak around the ability to stay.
Yeah, well, I heard Scott say, I hadn't thought about that, as if there was like an ongoing harm and, trying to make sure there was a mechanism to deal with that. But I do think generally requiring that people, and especially in these situations where you have conflicts that, between neighbors, essentially, right?
Yeah.
There's all kind of flavors of this. Like, I'm focused on the water quality because that's my scope. I understand that this bill will address a wide variety of situations that have nothing to do with that. Then as I said, my feeling is that the current law focusing on nuisance and the presumption that could be overcome by the burden of proof of this person alleging, that there is a nuisance that causes liability is adequate, but I certainly think mediation in those situations are really appropriate, because I think just by requiring that, you could probably work out most of these situations.
Thank you.
In the event, the hypothetical event that trespass was removed from this, but the burden still changed for nuisance. I don't want to make assumptions about how you feel about the bill, but if that were to happen, what would your position be on the bill?
I mean, it could be better from a perspective. I'd like to think about it, but consult with my colleagues, not get over my skis in the physical world or the rhetorical world.
I just wanted to toss that idea out there, but okay. Committee, any further questions, comments? Okay, sure. Thank you.
Yeah, thanks for that opportunity. Appreciate it.
And the next up, Attorney Bent, who is joining us via Zoom.
Hi, can you hear me? Can you hear me?
Yes.
Okay, great. Good morning, Senators. My name is Meryl Bent, and I'm the Managing Director of Wilmington, Campbell, Bent, and Stasny in Manchester, Vermont. I appreciate the opportunity to speak to you today about the proposed changes to the right to farm law, and I especially appreciate the opportunity to do so remotely, given the weather that we had down in southern Vermont. My law firm represented the plaintiff in what I believe to be the only case in recent history to which this law has been applied. And this case, the case that we were involved in, is an extreme outlier case. It's not a typical situation. And it wasn't even a close call in that case that the right to farm law was not intended to insulate the type of harm involved. In our case, even if the presumption had applied, which the court found that it didn't, the court found that my client would have overcome the burden because they'd showed that there were substantial adverse effects on health and welfare caused by the activity. I only found one other case involving the application of the right to farm law, which was from 2003. It was another water case. And in that case, like this one, the presumption did not apply in that case because the plaintiff's ownership predated the farming activity. So the case I was involved in concerned extreme changes to upslope farming fields and practices without any consideration for what would happen to the downhill property or to Lake Champlain. The upslope farm installed 119 miles of subsurface tile drains, which improve drainage for the farm, but have the effect of concentrating the water and then discharging it at a high velocity right onto and through my client's land. In other words, the flows of water were changed on the farm's property in a manner that physically invaded my client's property. And that's a violation of both the laws of nuisance and trespass. And while tile drainage systems may be a commonly accepted practice, and this provides an example of a commonly accepted practice that was implemented in an inappropriate setting and in an inappropriate manner. I'm not sure if I'm going to try to share my screen because I'd like to show you what kind of water we're talking about, just for some context. Let me see if I can send a request. I'm not. Oh. There we go. Screen one. Hopefully this.
Oh,
Can you see the screen?
Yes.
yeah.
Okay, I'm just showing you some flows onto my client's property from the neighboring farm. You don't need the volume. Sorry for the shaky video, but so just to give you some context, before the tile drain pipes were installed, this area had an occasional trickling stream when it rained. But the increased flows from the tile drains have turned it into basically a river rapid whenever it rains in modest amounts. And this is happening on multiple areas of this property now. The erosion from this kind of water flow has dug deep channels through a large area of land. And the erosion is so extreme that it interfered with the operations of the much smaller farm that was leasing my client's property. So this is the kind of damage that we're looking at that is, like I said, an extreme outlier type of situation. So.
Attorney Ben, can I interrupt you real quick just to ask a clarifying question? I think, so I guess, I'm looking at that video and also looking at the bill that we have in front of us. And while I'm not familiar with the water quality laws, my instinct is telling me that what I'm seeing on there is something that isn't a practice that would be consistent with proper and accepted customs, or the required agricultural practices.
Well,
So,
you.
Sorry, continue.
Sorry, keep going.
But no, that was pretty much it. Yeah,
Well,
it's that.
I think you're right about that, but unfortunately, the governmental agencies were aware of it, and the regulations failed to protect this private property owner. So it was important that they were able to have access to the court to protect themselves. I mean, what you just said, it's an extreme example, and the regulations didn't stop it. So this bill, I think, would replace well-established law that we are familiar with uncertainty and the potential for unintended consequences when it's not clear that there's a problem with the current law that needs solving, because this is the only case that I'm aware of that has gone through the courts, and it's an extreme example. But that's exactly, I mean, you're asking exactly the question that my clients asked. So the erosion, the water that you just saw, that goes through my client's property and it goes right into Lake Champlain. This is Lake Champlain. These are the plumes of brown water that are flowing from the farm through my client's property and into the lake. The water that was flowing through my client's property and into the lake was also shown to have increased levels of phosphorus and E. coli. This is another view of Lake Champlain. The contamination, oh, this is a picture of some of the erosion damage on my client's property from the increased water flows. And this shows that, you know, when it's not when it's not raining, it recedes, but you can see the extreme channelization that's caused by the water flows. And this is happening throughout my client's property to such a degree that they were not able to have access to certain parts of their property from other parts. It basically divided it into 3 separate islands. The contamination in the water causes increases in cyanobacteria known as blue-green algae. You're looking at that right here, and other deposits onto the lake and the lake shore. That's what you're looking at here. It prevents people from normal lakeside activities like swimming because it's not safe. And I want to also share with you that in our case, the plaintiff was raised on a large cattle farm. The plaintiff values and respects farms and farmers, and this was not a family who did not understand the challenges that farmers face, and this is not a family that would have complained about a minor inconvenience. The plaintiff also did not rush into litigation in this case. They asked for and engaged in efforts to resolve it well before resorting to a lawsuit. Before filing suit, actually, the plaintiff in this case, trying to stop screen sharing. The plaintiff in this case actually hired an expert from Cornell University to, at their own expense, first to make sure that they were correct about the source of the damage to their property, and then to literally design and propose a remediation plan that would have resolved it without the need for litigation. The plan they proposed was not accepted, and they were left with no other options to protect their property. And I'll also point out that while both the nuisance and trespass laws would permit them to do so, my clients did not ask for money damages in this case. All they asked the court to do was to stop the damage to their property. The law that is in place already prevents people, property owners adjacent to a responsibly managed farm, from pursuing nuisance claims against the effects of the farming operation on their property. It does not permit people to maintain an action against the effects of previously established farming activities already in operation. It also assumes that agricultural practices will change over time and that farms may be enlarged. Adding trespass to the right to farm law would absolve farming activities even when those activities physically invade and damage someone else's land. So the only recent case that I'm aware of, which is my own, is such an extreme and isolated example that it seems that the right to farm law, currently in effect, is doing what it's supposed to do. The law now in effect clearly discourages lawsuits. It requires people to carefully analyze the facts in the law before bringing their action. It's a really steep hill to climb for the plaintiff, who does have the ultimate burden of showing a substantial impact to health and welfare and to their property. I think the proposed change would upset that balance when there's not a clear problem to solve. And again, it would have unintended consequences that would inhibit Vermonters from protecting their health and what is usually their most valuable asset, their property, in the rare, extremely rare situations that would warrant it. It will also make it harder to protect against environmental degradation, which impacts everyone. But I mean, this case more focused on the damage to private property. So I just wanted to provide you with that example because I think it's important to understand that this is not a common situation. This was an extreme situation. And so if this bill is a reaction to this matter, I think that as Mr. Sanderson and Mr. Groban said, it's a solution in search of a problem. Thank you very much for hearing from me today. I'm happy to answer any questions if you have any.
Thank you. Committee, Senator.
Thank you for your testimony. I'm looking at, do you have the bill in front of you, the proposed bill?
Yes. Oops, I did.
Okay, I'm on page 4, and it's the definition of generally accepted agricultural practices. And subsection C of that says practices conducted in a manner consistent with proper and accepted customs and standards, ... I'm just wondering, if there's a protection there for an accepted agricultural practice that is being instituted improperly. Is that, do you view that as a protection for a plaintiff? Or is that just difficult to prove?
It's difficult to prove. It's a far more subjective standard, and I think that it's difficult because it creates a lot of uncertainty. And I also would say, just because you can find someone else who's doing it doesn't mean it's necessarily a responsible practice, and it doesn't mean that it's not causing significant damage to somebody else. So I think it closes the door where the current law as written has a pretty well established body of law that you can draw from and predict and understand what the outcomes might be and what the what the standard is.
Yeah. Yeah, I'm just trying to get clear in my mind what you showed us. I don't think anybody would argue that that's, even though tile drainage is an accepted practice, I think everybody would agree that it's been improperly instituted there. And I'm just wondering, under this new proposed bill, whether you would still be able to rest your case on that. But
I can't say that we wouldn't be able to. I think there's a possibility that it would still that this type of extreme case would still proceed. But again, I think it introduces a lot of uncertainty where currently there is not. And again, I think because you can see that this is such an extreme case and it's really the only case, what problem are we trying to solve by introducing that uncertainty?
thank you.
Any other questions, comments? Thank you, Attorney Ben.
Thank you all.
And before we go on to our next witness, Steve, after our next witnesses, would you mind sticking around? I just have questions about water quality to the extent that we can dive into that area.
Sure, I'd be happy to.
Great, thank you. Attorney safety. Support.
Good morning, ladies and gentlemen of the committee. My name is Claudia Safar. I'm a partner at the law firm of Bonning and Safar in Burlington, Vermont. I represent the Worstville Farm. At first, I prepared a presentation for you to discuss specifics of your proposed legislation, but I want to touch on a couple of points that were raised by my colleagues who just preceded me. First and foremost, I would like to address the video that was just presented to you by Attorney Ben. I think one really important fact that was omitted from the presentation there is that video was taken in the July storm this summer. The video evidence that was presented in this particular case that I was on the other side of representing the farm, those pieces of video evidence concerned two of the largest storms that our state has experienced in quite a long time. People lost their lives in the state of Vermont. So we have video evidence that is being presented to show an extreme case on two storm events that took out 4 culverts that had nothing to do with the drains within the town of Canton. This storm also cost individuals their lives in northern Vermont. It cost people their homes. It cost people their livelihoods. It was indeed an extreme case. I have a small video that I would like to show in response, which shows the water that was actually coming down Adams Ferry Road, which was that water that was entering her client's property that had nothing to do with the tile drains in this instance. So I think it's important to understand that lawyers can sometimes be masters of spin, and we can present our cases in ways that is not necessarily allows folks to see the totality of the circumstances. So just very, very briefly, I don't want to belabor this situation because I think there's much more to say on the actual legislation, but for what you can see here, this is a video that I wish I could, and I don't know if Kayla can. I emailed it to her just recently. I'm not sure if she can actually put that on her screen.
I can.
But this, suffice to say that this is a tremendous amount of water that is coming off of, this is surface water that is coming off of muddy and dirty town roads. There's miles and miles and miles of dirt roads in the town of Canton, as we have in many localities around Vermont. This water has to go somewhere, and unfortunately, it drains through 3 pre-existing town culverts that then drained onto Attorney Ben's client's property. So I have more videos that I've sent, and I'm conscious of my time limitations, so I'd like to move on, if I may, to the legislation. It's been presented by several of your witnesses that there's no problem here to solve, and I would submit to this committee that that's absolutely incorrect. This right to farm law is substantially flawed. It's flawed in several regards. I think this committee has noticed that in a couple of places, and I want to go through the flaws in that particular scheme. So first and foremost, this scheme sets up a rebuttable presumption. I, assume that this committee understands very much what a rebuttable presumption is.
You're talking about the current law.
Yes, the current law. So what do we have to fix? And what you've been told is there's nothing to fix here, folks. Everybody keep moving. We can just move along. No problem to solve. Only been one case, and that's been super extreme. Now, I think the elephant in the room is tile drains. And unfortunately, this particular case not only dealt with tile drains, but it also dealt with smell from a manure pit. So we've been, Attorney Groveman said, well, we're really focused on water quality. And I think part of what we're trying to do with this law is to address this practice of tile drains. And I think we have to hit this head on, because this is a current practice that is being implemented in a lot of places. It hasn't been implemented a ton in the state of Vermont, but it is something that is becoming more and more common. And so this is one of the very things that we are trying to address with this law. And I think that has to be acknowledged, because if we say, well, this is a unique case and it's sort of the regulators can't agree. Well, what is it that they can't agree on? We have perhaps a dispute as to whether tile drainage constitutes a point source discharge. And that's the dispute. And I would submit to this committee that the regulators need to get on the same page, but this should not be the burden of the farmer. In other words, we can't leave our farmers exposed to nuisance suits because we're saying, well, we're not really sure that the Agency of Agriculture and maybe A&R agree on whether this is a point source, and maybe there's federal issues with the Clean Water Act. Folks, those causes of action still exist. They still exist. And so we have to allow the experts to have those conversations, but that doesn't mean that we in turn leave our farmers wholly exposed to nuisance and trespass lawsuits. That's exactly what this is about. This is about protecting our farms. And I think Attorney Collier did a great job of explaining that. He started out with saying, let's remember that farming is food, and we all eat food, and we all need to support our farms, because this is essentially the lifeblood of the state, and it's the lifeblood of our society. And we have to figure out how we support those very people that are providing us with our necessities. So looking at this law, we look at what's wrong with it. So we start with this rebuttable presumption, and that rebuttable presumption, you only get the benefit of this presumption if you can meet these 4 A, B, C, and D, right? 4 prongs. And our first prong that we start out with is the idea that you have to comply with all laws and regulations. And this includes federal laws, state laws, municipal laws. And that's what the rebuttable presumption currently says, is that their practices are conducted in conformity with federal, state, local laws and regulations. Okay, so what laws? I guess that's the first question I ask. What laws? All of them? Speeding? Shoplifting? I'm not really sure. Laws that govern this particular activity that somebody is complaining about, which ones? And I have to prove that I'm in conformance if I'm the farmer. How do I do that? How do I prove that I didn't speed on my way here? If you're asking me whether I sped, I said I didn't, but how do I prove to you? I have to prove to you that I didn't do it. Does that mean I have to have a speed gun with me the whole entire way? I'm just using this as an analogy so that someone can understand. How does a farmer prove a negative? How do they prove that they didn't violate the laws? Well, they can say, well, I haven't been cited by the agency. Nobody told me that I was in violation. I don't have any violations. Well, this judge in this particular instance said that's not enough. It is not enough. The absence of regulatory action against you is not enough. You have to do more. How do they do that? It's impossible to comply with. So right then and there, if I can't prove that I'm in compliance, and just the fact that I haven't been cited isn't enough for a judge, I can't do it. There's no way to comply with prong one. So now I've just automatically point blank lost the benefit of that rebuttable presumption. So there we have it. Just looking at prong one, this law is entirely ineffective. It doesn't help the farmer. Bam, we are out right away. But I can keep going further. We can go to prong number two. It's consistent with good agricultural practices. What does that exactly mean? What are good agricultural practices? I think Attorney Collier took you through this regulation as well and said, look, this is ineffective on all four prongs. So this is part number two. Now, we don't know exactly what does good mean. What are good agricultural practices? This can be debated. It can be debated by experts. Now we're in court. We've got experts arguing with, well, that's not good. I don't like the fact that you no-till, and I don't like the fact that you manure inject. I really want you to do it this way. So now we've got another debate that's happening at prong two. Now we move on to prong three, is established prior to the surrounding non-agricultural activities. Again, I would reassert, Attorney Collier said, what does it mean, surrounding activities? How far are we going out? We're going out a radius of just immediate neighbors, going out a mile, going out 10 miles. That smell from that manure pit, gosh, it travels 4 properties down. I don't like it. So I don't exactly know what that means either. Then I move on to prong D. It has not significantly changed since the commencement of the prior surrounding non-agricultural activities. Now, this is another huge whopper that we have that makes this law entirely ineffective. So if we think about that for 1 second, has not significantly changed. What's the purpose of this right to farm law? What's the purpose? The purpose is, and I would submit to you that it's articulated right in 12 VSA 5751. The purpose of this right to farm law, as the legislature has explained it, is to protect reasonable agricultural activities from nuisance lawsuits, to encourage improvements by farmers, and to allow farmers to change, diversify, and expand. So if we have taken and given them a rebuttable presumption that is hinged on having to show that they have not significantly changed their practices, how do they improve? And improvement is necessarily a significant change. So just by virtue of not staying with 1920s farming practices, which we can all agree, we want them to progress. We want them to do things that are innovative. We want them to do things that are advancements. But then they implement the advancements and they have de facto taken themselves out of the benefit of the rebuttable presumption, which is the very scheme that this law sets up to provide protection to farmers. So in other words, you advance, you can't get the benefit of the presumption, and now you are exposed. So I think that the narrative that we don't have a problem ignores the very logical inconsistencies in this law that does not actually provide protection. And simply because people have not come forward to avail themselves or file lawsuits based on this law, where it's had to be set forward as a defense or attempted to be used, does not mean that it is not flawed. This one case is extreme, and it has, my client will next be able to explain to you how it has extremely impacted that particular farm. But this is only the tip of the iceberg, folks. And I say that because tile drains are just at their very infancy. Farms are going to be putting these in. This is not a rare event. It is the beginning of what is a waterfall of these types of claims that can be coming. And we have to do what we can in order to protect our farming community. Now, I think that the next question is, does this law accomplish the goal? And I would submit to you, it absolutely does. It encompasses both nuisance and trespass. Now, I know you've been told that's a bad thing. We don't want to okay, maybe if we're going to talk about nuisance, but let's not talk about trespass. I think when you look at the problem in the context of tile drains and also smell coming from cows, you understand why trespass is also an important tort claim to envelop in our legislation. It's really important because it's the other claim, it's the other mechanism which may be used to bring a claim against the farmer. It's not just nuisance, it's also trespass. And this water and smell can also constitute a trespass. And in fact, in this case, it was argued that it was a trespass as well as nuisance. And so we have to address both. We cannot leave one outside of this circle. We cannot leave the farmer exposed on one half, but not on the other. So I think that this law has covered both prongs. That is essential. That is important. And I applaud the drafters for recognizing that.
Can I ask a clarifying question?
Yes.
Going back a couple points to the 4 prongs under the current law. So the committee that's at the bottom of page 4, where there's a strike out. It's my understanding that, let's say, that the farmer is acting in conformity with the laws. They are being consistent with good agricultural practices. And it was established prior to surrounding non-agricultural activities. But to that last point of somebody making a change to improve efficiency or do something else, if they make a significant change that completely removes their protection, it removes their protection.
Correct.
Okay.
Correct. And in this case, in the case that Attorney Bent and I were involved in, one of those changes included the development of another manure pit. So we're asking farmers to store manure for periods of time so they can spread it at appropriate times and make sure they've got adequate storage. So our farm added another manure pit. That was one of the things that disqualified them from the rebuttable exception. So, I think I have also attached for your consideration some exhibits that I think is really important. And I have one of the exhibits that was presented at trial was this is the water that's coming out of the tile drains. And we took the judge to look at these 16 discharge pipes. This is the water that is coming out. And as you can see in your images, you can see one that is a close-up of the cup, and the other one is my client drinking from it. It's crystal clear. The water that's being shown in these videos is coming from surface water. It's coming from dirt roads. It's coming from, if you know anything about town of Canton, there is clay. The soils are clay soils, which are highly soluble. That is the sort of murky water that you see. It's coming from the surface, not from the tile drains. You'll also have in your packet some water testing from Endyne, which is water testing that was conducted by our engineers that's coming out of the tile drains in that instance. That will show you that it is very low in phosphorus. It's almost non-existent VODs. All of the numbers are extremely low and well below any of the standards for water quality. So I think, unfortunately, there's a determination that we are violating water quality when the reality is that what's coming out of these tile drains is crystal clear, it's drinkable, and it was not contaminated water. Here we are with adverse determinations, but I think what's important is to understand that there is something here to solve, and this case is a shining example of what needs to be solved, and there are many more cases that are probably going to come down the pipe with similar issues, just like this particular case. So at this point, I would like to cede the remainder of my time to my client to explain to you from a personal perspective.
Thank you. Before we do that, committee, are there any questions, comments? Okay. Thank you.
Morning. Thanks for having me. So as Pauline said, I'm farmer that's involved in that litigation.
Sorry, just for the record, could you just state your name?
Oh, it's Gerard Borsfeld.
Thank you.
Sorry.
No problem. Please continue.
So, okay. Thank you for having me here today. I would like to share my experience with the right to farm law. I farm with two brothers in Banff, Vermont. We've been in litigation with a neighbor for over 5 years. The current right to farm law does not give much protection to farmers, even if the farmer is following all the rules and going above and beyond the rules. Let me give you an overview of the case. In 2013, a large next door farm that was owned by a lawyer came up for sale. We purchased the farmsteads, buildings, and 1,500 acres of farmland as it was right next door. The farmstead and about 350 acres sit uphill and across the road from the lakefront portion of the lawyer's farm. In 2014, the neighbor purchased the lakefront portion. Almost immediately after purchasing the property, we began improving the farmstead and the land. We installed two manure pits and made other improvements to the facilities. The land was improved by removing overgrown brush, trees, converting old pasture into fields. We took out hedgerows and combined fields to bring them up to modern farming standards. We worked on surface drainage and installed subsurface drainage tile. All this took years to complete. In the fall of 2015, the new neighbor approached us about wanting to purchase the farmstead and 200 acres of land. We had no intention of selling it as we were using the facilities. Soon after that, the neighbors started taking pictures. They spent several years taking pictures and videos of our property and activities. They had taken thousands of pictures and hours of video and drone footage. In 2019, the neighbor's lawyer sent our lawyer a packet written by their expert they had hired of what they didn't like on our land and our farming practices. They wanted a meeting with us, which we did. They pretty much told us to farm in the manner that their expert had laid out for us, or they would take us to court. They had spelled out how we were to farm our land and have regular annual or biannual inspections by them to see if we were meeting their standards and if changes were necessary to their recommendations. And they wanted that to continue until they were satisfied. They had issues with the water running onto their property from ours and some other abutting land. The water crosses the road through 3 culverts onto their property into 2 gullies which flow into Lake Champlain. The water has always gone through those same 3 culverts. In late 2021 and early 2022, we went to court. The complaints were water trespass, smell, flies, and traffic. They were able to convince the judge that the subsurface tile system was ruining their property and lives. The judge decided that in their favor, due in part to the right to farm law. At trial, we didn't prove to the judge that we were complying with all the rules. Quote from the judge saying, quote, evidence of lack of enforcement of RAPs does not support an inference of compliance, end quote. We had 3 people from the Department of Agriculture testify in court. They could not testify that we were in compliance because they were not expert witnesses. They could only testify that we were not in violation of the rules. At trial, we also didn't prove that we didn't significantly reduce the agricultural activities. Quote, the Borsfelds do not use the traditional method of tilling their cropland. This had been the practice done by Dennis Miller when he made his farm. End quote. We used to till the crop fields, but now we inject manure and grow cover crops. This method is much better for the environment. It has changed the soil, making it much healthier and productive. We farm about 2,700 acres, 1,000 acres of it is grass and alfalfa, 1,700 acres is corn. We don't till most of our corn and minimal till only when necessary. All the manure is injected in the cornfields and cover crops grown in the off season on all the corn ground. These changes we have made over the last 15 to 20 years.
They are promoted by the state. We have worked closely with UVM Extension on cropping techniques and soil information. We have a good relationship with the Department of Ag. They have helped us with manure pits, leachate systems, and other issues. We get inspected once a year, and they do find minor issues or potential issues. We try to correct them quickly. We like to be proactive on regulatory issues. We have been in court several times on this case. The judge is not clear on how we need to comply with her injunction. We hired an engineer to design water quality improvements that we installed last winter. The cost of that was around $50,000. Neither the judge or the neighbors were satisfied with it. Last fall, we went through and plugged all the tile outlets. Now we're scheduled to go back in court in late April. The case is never going to end. The issue of smell was brought up once in the last 3 years. The fly issue never came up, and they dropped the traffic complaint. The neighbor has way more resources than we do to throw at this case. We have spent hundreds of thousands of dollars on this, and there's no end in sight. We told my brother this past summer he's not going to stop till we're out of business. He has the wherewithal to do that. Who should decide what Farmington can do? The law or the neighbors? Our neighbors were hoping to be able to regulate us much in the way that the state does, only to their standards. If farmers are doing things correctly, they should have some protection from nuisance and trespass lawsuits. Let the appropriate agencies regulate the farms to hold them accountable for following the law. Even the neighbor's expert witness that was in court in unrelated conference stated that if a farm was following all the rules and doing things correctly, they can lose in a court of law.
Thank you.
I would like, if I have time, I would like to have like that video. Yep, that's what happens. What they don't tell you is it's clay soils, which are colloidal, it turns water brown pretty quick. That happens everywhere in that part of town with that type of soil. It's all brown. I don't remember exactly what video. I've seen that video. I don't remember exactly when that was taken, but it was a good rainstorm, probably an inch or 2 or 3. They convinced the judge it's from our tile drains. I know that our tile drains actually are helping them with what they're complaining about. Before we tiled it, I've lived here since 1979, driven along the road many times. You can see the brown water crossing the road. And I know that it's better with our tile drains. Problem is, we didn't document things before we went to court, before the rate changes. That's what people love for you.
Thank you for your testimony. I do have one question that I think would probably be best directed to your attorney. You had mentioned, well, your client had mentioned in court that there were agency of ag witnesses that testified that the rules weren't being violated, but they could not testify as to the required agricultural practices because they weren't experts. Is that accurate?
Yeah, so I will start by saying that I was not trial counsel, but as you may know, and this is not a knock on federal agencies, what they want to be careful of is that if you subpoena a witness, such as an example as a water quality expert, for example, or a water quality regulator from the Agency of Agriculture or someone from ANR, and you subpoena them to come to court, they don't, first and foremost, don't want to have their employees coming to court in private lawsuits. It's understandable. And what they can't have and don't want to have is their employees then being used as experts in private lawsuits. So they will come to court. First of all, they will move to quash the subpoena through the Attorney General's office. It happens every single time. And then they will bring their witnesses when they are compelled to simply say what happened in this particular case. So they will testify factually. Are you in have you been cited for a violation or not? That's what they will testify to. If you ask their opinion, that is considered to be an expert opinion, which they will not render in a court of law. And they will not say, we believe that the Wurstfelds are in compliance with good agricultural practices or in compliance with the RAP. They will simply say, have we cited them or have we not cited them? And that's an understandable practice, right? Because if they start doing that for one person, are they going to do it for all? And so that just sets up a scenario where we cannot call regulators to say, are the clients or is this party doing things the right way? They will simply say they're not cited. We don't have any violations.
And so just wanted to confirm that piece, but so the next piece, if you were to get expert witnesses to testify that they were or were not following standard agricultural practices, that would be, well, first, rough estimate, how much would that ordinarily cost the defendant?
Oh my gosh. I mean, you can't have an expert. I would say there's no world within which an expert is going to collect data, prepare for testimonies, sit for depositions, attend a trial that's a 5-day trial, and then, come forward for numerous hearings thereafter for anywhere less than $40,000-$50,000, right? Like that's just like a base. That's probably going to be your baseline, and then it's going to go from there depending on what the expert has to do.
And that would be for the defendant to prove, essentially to prove a negative.
Absolutely. And who knows what needs to come from that, right? Is when we're talking about something like tile drains, for example, it's subject to a lot of discussion all around the country as to, where is this? And also, part of the problem in this instance is that tile drains in clay soils do not necessarily behave in the same way that they do in Iowa, for example, than they do in Montana, right? Like we have different soils all over the country, and tiles are going to behave differently. So you may have a study out of one place that is not going to be applicable in Vermont necessarily. And so you have to have experts that are going to be able to ferret that out and explain all these differences to the judge, right? And then the question is, how do you get an expert on smell? That's also a really interesting issue, right? Like, how do we prove something? I don't, we hired somebody out of Cornell University that had experience with design of manure pits. But I guess my point is simply that like expert testimony is a really complicated thing. It's an expensive thing. And there's a question as to, for some of these potential nuisance allegations, how do you even get an expert for something like that? Right. So it's a little trickier than I think people understand from a practical perspective. I'm not sure if that answers your question.
It does. Thank you.
Yep.
Committee, any further questions?
I've got one. Thank you. In reference to following up on the chair's question, such as I did last time, I asked Mr. Grove, and it appears that the present bill, if I accuse you of something, the accuser has to show that no, we're not in violation. Does this present bill put the burden of proof now on the accuser versus the accused?
That's correct. And I think that's absolutely proper. That is 100% proper, because particularly in light of the current law, there's no way to prove the things that the farmer is being asked to prove, right? It's a litany, it's a 4-part test, 2 of which are, as we went through, the last one is not what we want to be accomplishing. And the first one sets up a scenario that's almost impossible to prove. So I think what this law has done as it is currently drafted is correct to shift that burden to the plaintiff. Tell me what you think I've done wrong. It's a base level allegation, right? So as opposed to having to prove all the ways that I'm doing right, tell me specifically what you think I'm doing wrong. And then we can address that particular thing. So I think that burden shift is correct.
Thank you.
Any further questions? Sorry about it.
Yeah, I'm just curious. So you've plugged your drain tile, and now your lands, like my everyday life, I do excavation. We have some clay up in Milton. It's always a pleasure working with clay. I'm just curious what the quality of your fields are now that your drain tiles are plugged, because I'd imagine your pattern on your fields is probably pretty tight. Yep. With those heavy clay soils. I'm just curious what your fields are like now, because my understanding for drainage tile is that it meant to keep those surface waters off the surface, the grounds to be able to absorb the nutrients, and then the end goal is that clean drinking water that comes out the end.
Correct.
So kind of what your fields look like now that those drainage tiles are.
So we put them in right around Halloween.
Mhm.
It was dry all fall.
Yeah.
So not much water was coming out of them anyway. We had some rain middle of December. I walked it. Didn't really notice much, but like I said, been dry all fall.
Mhm.
And we haven't had much precipitation till a week or two ago.
Yeah.
So now it's all snow covered and
Yeah. Probably the spring.
spring I'll find out. So I think I'm gonna lose a bunch of land. That's gonna be too wet, so I think the water's gonna just end up sitting in the soil.
And then you can't farm that, and then also,
Well, then,
cause erosion in your field.
so we gotta go back to court and prove that our water coming out of the pile outlets is not going across the neighbor's property. So I have to figure out how we're gonna prove that. And we're set up to pay $1,000 a day fine for every day that the tile water is going across the road. I don't know if I'm supposed to check what day there's water going across the road, where that water came from, if it's from my tile. I don't know. So that's the predicament we're in. In a next to impossible situation that I don't think we can win. So losing a little bit of land, that's the least of my concerns.
Committee, anything further? Thank you for your testimony. And Steve, you mind